You ever wonder why some trucker on the highway looks like he hasn't blinked since Tuesday? That's not just bad coffee, that's fatigue, and it might be the reason your fender bender turned into a full-blown lawsuit. Fatigue messes with your brain almost exactly like alcohol does, which sounds dramatic until you learn that being awake for 17 hours straight impairs you about as much as having a couple drinks. So when a driver has been behind the wheel way too long, their reaction time turns into molasses, and molasses does not stop in time for a red light. That is where hours of service rules come in. And no, that is not the name of a boring accounting firm. It is a set of federal regulations that limit how long truck and commercial drivers can drive before they legally have to rest. Think of it like a video game with a stamina bar, except if you ignore the bar in real life, people can actually get hurt. Commercial drivers generally cannot drive more than 11 hours after 10 consecutive hours off duty, and breaking that rule is not just a slap on the wrist. Here's where the lawyer stuff gets juicy, because an hours of service violation is basically a golden ticket for proving negligence. If a truck company pushed their driver past the legal limit and that driver crashed into you, that logbook becomes evidence, almost like a diary that snitches on itself. A lot of people assume these logs are handwritten and easy to fudge, like something out of an old detective movie. But most trucks now use electronic logging devices, which track hours automatically, so drivers cannot just scribble in extra sleep hours that never happened. Still, some companies get creative, pressuring drivers to falsify records or skip rest breaks to hit tight delivery deadlines. When that happens, liability does not just fall on the driver, it can climb straight up the ladder to the trucking company itself. This is called vicarious liability, which is a fancy law term for the idea that the boss can be blamed for the employee's mistakes. If a company knew their driver was exhausted and let them drive anyway, that is not just bad management, that is a lawsuit waiting to happen. Now you might be thinking, okay, but how do lawyers even prove someone was tired? They pull logbooks, GPS data, dispatch records, and sometimes even the driver's cell phone records to build a timeline of exhaustion. It is basically detective work, except instead of solving a murder mystery, you are solving why a truck the size of a small apartment building drifted into another lane. Expert witnesses sometimes testify about sleep science too, explaining how fatigue impairs judgment even when someone feels fine. That last part surprises people the most, because tired drivers often think they are okay right before they are very much not okay. It is like insisting you are fine to text and drive because you have done it a million times before, right up until the one time you do not. The scary part is fatigue-related crashes are common enough that safety groups have studied them for decades, and the numbers keep showing the same pattern. Long shifts, tight schedules, and pressure to deliver fast create a perfect storm for accidents. So, if you get hit by a commercial driver and something about the timeline feels off, do not just assume it was a random accident. Pull the logs, check the hours, because sometimes the real cause of the crash is a company that valued a deadline over a driver's sleep. At the end of the day, preparation beats panic, and knowing your rights turns confusion into action. Understanding fatigue and hours of service rules will not undo a crash, but it might just help you win the case that follows. If you want to learn more about how we handle cases like this, check out our links in the description.